Hi, I'm Kristen Osenga, and I'm going to break down the Supreme Court's recent decision in NCAA versus Alston. The National Collegiate Athletic Association, or NCAA, is the organization that brings us college sports, from football bowl games to March Madness to the College World Series, and so much more. Before the NCAA stepped in, college athletics was basically the Wild West. Unscrupulous boosters, widespread corruption, and serious safety issues. And you can read about some of this fascinating history in the first part of the Supreme Court's opinion. Starting in 1948, the NCAA began imposing rules to both protect student athletes and to protect the amateur status of college sports. It is these rules that form the basis of antitrust claims brought by a group of current and former student athletes. The argument is that the NCAA's rules that restrict compensation to student athletes are unreasonable restraints on competition. So basically, antitrust law exists to protect competition. And the idea is that, in general, a well-functioning market can take care of itself. If a market participant is going to artificially restrain that market, it has to have a good reason. Here, the NCAA is the market for college athletes. And in that market, schools are competing for student athletes. The NCAA's rules on student-athlete competition artificially restrains that market. And because there's really no other place for student athletes to go to play collegiate sports, when the NCAA imposes these rules, the market isn't going to and can't take care of itself. And so antitrust law steps in. The basic argument from the student athletes is that the competition among schools for athletes is unreasonably restrained by the NCAA's rules on compensation. The NCAA's argument, on the other hand, is that in order to protect both student athletes and the idea of amateurism, which is not defined anywhere, the rules are necessary and therefore are not unreasonable. At the district court, the court allowed the basic competition rules to stand. That is, student athletes still can't just be paid for their participation in collegiate athletics. But the district court did strike down the rules that limited education-related compensation. For example, the NCAA had imposed limitations on paying for things like tutoring, study abroad, postgraduate scholarships, post-eligibility internships, and the like. The district court noted that the NCAA, in not allowing players to be paid outright, was maintaining a clear line between amateur or collegiate athletics and professional sports. And that distinction was sufficient to allow the rule regarding outright payment to stand. However, with respect to internships or scholarships, there's no chance of blurring the line between collegiate and pro sports. And so those restraints on trade were found to be unreasonable, not required to maintain the NCAA's mission. Both sides appealed to the Ninth Circuit, which affirmed in full, but only the NCAA petitioned for cert at the Supreme Court, and the court makes very clear that the students' arguments regarding basic compensation, or outright pay, were not before the Supreme Court in this decision. In a 9-0 opinion, authored by Justice Gorsuch, the Supreme Court affirmed the decisions below. Education-related compensation rules imposed by the NCAA are an unreasonable restraint on trade and cannot stand. A lot of the Supreme Court's opinion is directed towards what level of scrutiny to use when reviewing the NCAA's rules, which is interesting for antitrust geeks like me, but probably not more generally. So let's just stick with the merits. Bottom line, the Supreme Court agreed with the district court with respect to the idea that the NCAA's rules that limit educational-related compensation for student athletes should be stricken down as unreasonable. And in part, because the court recognized the district court's injunction was very narrow, it can stand. So, as the court noted, the injunction is narrow. It's not going to open the door for money from boosters or shoe companies to be given to student athletes. And the NCAA retains wide latitude to determine what is and isn't an educational-related benefit. For example, as Justice Gorsuch wrote, the NCAA can say it's not educationally related to give a student a Lamborghini to get to classes. Plus, the conferences themselves have the ability to impose more stringent rules as long as it's not the NCAA-wide. What's perhaps more interesting is the short and rather scathing concurrence filed by Justice Kavanaugh, where he noted the NCAA's basic compensation rules, the outright pay rules, are unreasonable and that student athletes should be paid. At a time when the NCAA is under attack from states, as a number of states are currently implementing laws that allow student athletes to benefit from their rights of publicity, Kavanaugh's decision, concurrence, holds open yet another avenue to challenge the already beleaguered organization. There's a good chance that college athletics is going to look very different going forward, and I think it's going to be exciting to see.